The reason why you fail is not because you are not intelligent. The reason why you fail law question is not because you don't study early. The reason why you fail is not because your lecturer hates you. The reason why you fail is not because the course is too big to pass, but because you have over time failed to know how to answer problem questions. You have over time neglected the art of answering problem questions, thinking that it all ends with your reading, thinking that it all ends with staying throughout the night without sleeping a day to the exam. If you have not mastered the art of answering problem questions, this very video is for you. At the end of this video, you are actually going to understand the format of answering problem questions and at the same time improve your CGPA and better your career as a legal practitioner. Stay to this video. My name is Kingsley, better known as King's Advocate. I'm currently a 400 level law student, and what I do on this channel is to help law students, providing them with insight, case analysis, and how to solve various topics in the field of law, and also promoting awareness video. If this is the first time, you can consider subscribing so that you'll be receiving our videos as it happens. And again, like the video. Let's continue. Now, when you talk about how to answer problem questions, there are different things that you ought to know. And this video is our furtherance to our part 1 video on introductory to how to answer problem question. You can actually check that video by clicking the link above and come back to watch this one, which is the part 2, or you can still continue with this one and after you go and watch that video. I believe you are not a robot. You can always track knowledge no matter however it flows. So, but that one lays the foundation. There are so many things said here I'm not going to repeat here. So that's why it is often advisable you watch it, but regardless, you are in primary 2 without going through primary 1. That will not be a problem. So when we come to answering problem questions, there are various principles that are developed on how to answer problem questions. We have IRAC, which stands for Issue, Rule, Application, and Conclusion. Then we have IPAC, which stands for Issue, Principle, Application, and Conclusion. Now, on our previous video, we examined everything that has to do with IRAC. So what we are focusing today now on this part 2 video is IPAC. So what is IPAC? IPAC actually is not different from IRAC, so to say, in its straight legal analysis. But then, the difference is only said in one word, which is what? P, as opposed to R. That is the only difference as far as King's Advocate is concerned. Other people may have their own differences, but that is the only difference. When you talk about principles are like basic rules or code of conduct or ideas that governs how the law should work. It is different from rule in the sense that where the rules apply, it applies in toto. I will still explain, calm down. But where principle applies, the court is not bound to take it in toto. In toto means exactly as it is. That is, apply without dilution. If the law says that, according to section 36 sub 12, that no person shall be punished or arrested on the account of crime that is not written down or stipulated and the punishment thereof provided, this is the rule and it's non-negotiable. You cannot say, I'm court of magistrate, I will not apply it. There is exception. This applies what? In toto. But principle doesn't actually apply in toto. Are you getting my point? Examples of principle is nemo dot old non habet. Is a Latin maxim and also a ancient principles of law that no man shall give what he don't have. It has more, it is more in practice in the commercial law, business law, contract law, equity. This is where you get it. You also have the rule of natural justice. Nemo judes in causa sua. No man shall be a judge in his own case. We also have all the alternative patem here from both sides. We also have, less vigilantibus, non-dominantibus adjuret. The law help the vigilant or aid the vigilant and not the dormant ones. These are principles of law. They are not rule of law. Now, before we go there, now I believe we have established that difference between the IRAC and IPAC. Now we focus on what we have come here to do, which is IPAC. So, as a problem question, you can only use, like I said, if you are watching for the first time this video, you may think I'm omitting a lot of things which are not helpful to you, but I will not repeat it because of those who are watching this video in furtherance of our earlier video, so they will not deem it as repetition. So either you watch this one and later on and go back and watch it, because I have omitted a lot of things about problem question that you ought to know if you are just watching this one for the first time. But let's continue. So when you come to problem questions now, there are ways you can use IRAC, there are places you can use IPAC, then there are places you can use CREC. We have done IRAC, we are now in IPAC. So IPAC is only used, or IPAC is a strategy adopted when it becomes obvious that there is no rule of law or authority covering that field, or not there is none, but because of your own inability to remember a particular sections of the law, or a particular judicial authority, or a particular, pronouncement, then you decide to rely on what? IPAC. Am I making a point? Please, if I'm making a point, tell me in the comment section. If I'm not making a point, also tell me. It will guide me to correct this video. Thank you. So now we have known this now. If a lecturer gives you problem question, the problem question have come to you as a law student. It took you unaware. You don't know what to do again. You don't know any section. You are not sure of section. You are not sure of judicial authority. Remember in my last video on this problem question introduction, we talk about types of courses we have: statutory based courses, judicial based courses, and so many more. Now, this is where it gets more tricky. If you don't have a particular section in mind, and that question is composed, because I normally advise, wherever you don't know authority, or if you get to hall and you kind of forget everything, it do happens, please run away from problem question, because the way of grading problem question is based on the authority you cited. The more authority you cited, the more mark you will have. That's why you may end up having a extra sheet, but somebody that didn't write extra sheet will score more than you and get A. Why you that carry the extra sheet shouting for all, sir, extra sheet, will still get D? It's because of this thing. You go choose problem question, you go explain tire without evidence. What is the need? Section 131 of Evidence Act made us to understand that he who wants the courts to rely on his facts he established to give judgment must adduce evidence that substantially prove those facts to exist. That is what we commonly say, he who asserts must prove. Section 131 of Evidence Act. So where you lack authority, please, my dear, run away from problem question. Choose AC. But if you have the authority, you can remember it vividly, then marshal problem question, because it will be more easy. Whenever I have authority, I don't even go to AC, because AC will waste your time and the lecturer may not read it. But if you write problem question, the lecturer is seeing, for me that I use red pen to write, to embellish my work. Don't be, if you're not in school, that accept red pen. I use red pen to cite authority. When the lecturer see it, it will look garnished, garnished with cases everywhere, red pen, shiny. By the end, you get A, the law. So that is where it becomes relevant. Now, if you don't have any authority, like I said, go to essay questions. But then we are talking about a situation whereby the lecturer have given us questions, and the only thing left in our mind now, the question is compulsory, and we don't know what to do. It is number one, compulsory, that you must answer it. I don't have authority. What will I do? That is where you apply IPAC. You can't tell me that as a law student. That is where everything helps. What you do as a law student matters. That is why every foundation is building you. Because this thing IPAC I'm saying now will only help you if you know what I'm trying to say now. You want to know Latin maxim like a law student. Should I begin to cite the one I know for you? To make this video long, it's many. I know many. And I don't know it. I didn't. In fact, all my knowledge of Latin maxim begin to diminish immediately I finish 100 level. It was the 100 level that I know all the Latin maxims. Because known as a fresher, hot Lord, I want to be cruising in Latin maxim. Lex vegetative, not dominatibus adjuris, lex injusta, no lex lata, delete ferenda. All those things. Saying it to make mouths, to feel the vibes, confusing my social science roommates. When you get to 200 level, you will know that there is more to law than just cramming Latin maxim. It will not take you anywhere. So, but now, that foundation you have laid will help you in 200 level, 400 level, 500 level, and even in law school. So a situation whereby you are confused, you don't know what to do. They ask you a question that has to do with a breach of fair hearing, and you are meant to advise the party, and you have raised issue, whether fair right is an issue or not. You can't remember the section of the Constitution that has to do with fair hearing. Which section that has to do with fair hearing? Which section? Tell me in the comment section. I won't say it. So if you can't remember the section that has to do with fair hearing, what will you do? You can say, relying on rule of natural justice. What are you applying? IPAC. Relying on the rule of natural justice, which says, oji oterem patem, hear from both sides. The right to this person has been breached because he was not given fair hearing, and the court went ahead to convict him. Remember, I'm giving an example. You just have to fashion it the way it will flow with what you are writing on the hall. I can't cover everything. So if you don't know, again, the one that has to do with somebody standing being a judge on his own matter, you apply Nemo Judas in Kosasua. If you are writing on commercial law and you can't remember any section that talked about passing a defective title, that a person who doesn't have the right to ownership cannot pass that title to a buyer, you can rely on Nemo that code non habet. A buyer cannot give what he doesn't have originally, and that makes it a defective title. And that's why title did not pass under sale of goods, under hire purchase. Are you getting me? Are we talking about legal method? Let's reasonable, non-dominatables, accurate. The law aid the village and not the dominant one. If somebody sits and his right is being violated, he refuses to go to court, you are advising him, and they say advise this relevant party. Or the lecturer have asked a question and say advise the party. You say, I encourage Taiwo to go to court immediately since his right has been violated, because delay is dangerous. And the law says that according to the legal principles of less vigilantibus, non-dominatables, accurate, if Taiwo refuses to go to court and delay, it might lead to laches and acquiescence, which simply means that a person who reluctantly waits for the defendant to suffer in his own peril is waiting in vain. So that is what IPAC stands for. That's why I told you there is no actually difference between IRAC and IPAC. It's just that P and R is the only difference. I've talked about how to raise issue. I've talked in the previous video. Then when you talk about issue, well, I'm not going to dwell much on that because we discussed it on the previous video. Issue basically has to do with, that point of fact or point of law that are in dispute between parties. You could see issue this way. Issue could be issue based on fact or issue based on law. If you talk about, like I've advised issue to tell you that issue basically has to do a point of fact or point of law that is an issue. I'm using words to define what. Sorry, let me find a way to define it again. What I'm trying to say is that issue can be defined as a point of fact or point of law that is in dispute between the party to a claim or to a matter. On the academic field, because I don't want to go court-wise, we are not in court yet. We save that one thread for tomorrow's, upcoming. Let's leave it for that. So on academic perspective, issue simply means what the lecturer wants you to do. What the lecturer, have painted. And then he requires you to know that this is the main problem between all these things I've written here. All this, should I say ranting? You can call it if you like. He wants you to pick that thing that is the issue. That's why if you go to a market, you see people fighting. Or you come back and see your two roommates fighting or lodge mate fighting. The first question you will ask them is, what, apart from being a lawyer, I want to ask you this. If you come home and see your roommates, two girls fighting in the hostel, two boys fighting in the hostel, and you are the third party, what will be your question? What will be your question to them? You will tell them, please, what is the problem? Please, what is the issue? Why are you people fighting? Are you not saying they are fighting? Why are you asking what is the problem? Why are you asking what is the issue? You are not asking because you are deaf, or because you are dumb, or because you can't see. But what you are asking is, what is the reason for your fighting? Are you getting it? So the lecturer actually knows that he has wrote a lot of things in this question. He wants you to know that thing that is the problem. You have seen the fight. You have seen the exchange of blows. In fact, you collected the one when you were trying to separate. Then you are asking them, what necessitated this fight that led to this blow I received coming back from early afternoon lecture? That is the issue. So take issue that way. Now, when you have identified that thing that is the problem, the next thing is the law. And in this case, we are not going with IRAC because we are not dealing with IRAC. We are going with IPAC. Then you apply principles of law. I have pointed out principles of law. Principles of law could be ancient Latin maxims. They are not just in Latin maxims. So don't see it as just because it's a Latin word. There are principles of law that was not altered. What makes it strong is that Latin origin, because it is undiluted. Of course, are you aware that law originated from the Norman and the Roman Empire? In case you didn't do your legal method. No, law has its origin from the Roman Empire through the Norman conquest. I don't want to go there. So because of that, from there it gets to common law. Because of that now, you see that thing is undiluted. Nemo dot code no habit. It was not tampered with. all the principles of equity, like equity aid the vigilant, equity act in personam, equity will not suffer a wrong without a remedy. These things, equality is equity. These things are all valid authorities. Are you getting me? That is where principle apply. If I a guru, a strong law student who knows his onions and Maggie, you can actually apply this equity, this principle IPAC and IRAC in the same question and smash your A every time. That is the secret. But if you don't know how to apply, if you don't have rule, you rely to IPAC, but rule is preferred by IRAC. So are you seeing how it applies? Now we get to the application. Remember we said issue, rule, now principle, because we are dealing with IPAC. Then we'll come to what? Application. Application is that place you marry everything in the facts with the rule or with the principle. Yes? They have told you that adultery, based on the facts you have seen, the lecturer in legal method printed a fact that has to show that somebody have committed adultery in the north, in the south, and they are charging him to the courts. They have shown you everything there. You have seen it, you have read it, you know. And now, no, I will not share this secret here. And in part 3, I'll share this, how to identify issue. It's in part 3. Let me not preempt that. So, and now you have identified the issue, you have, you know, covered everything. You then be like, based on the principles of law here, I'm talking about, we are now answering the problem question. Part 3, we are still going to face it. I'm going to craft a problem question and answer it in real time. So you see it. You understand? So now the lecturer have painted that question. We are now answering it. You have stated the issue, and I want you to know, like I stated in the last video, please, when you are talking about IPAC, IRAC, it's not a mathematical formula. Don't go and start writing to your lecturer. They have asked the question, you come to the center of the book and say, IPAC, oh, issue, oh, rule, oh. The only thing that cannot be silent is issue. You can say issues, or below are the issues. If you like, you can see just itemize it. If you don't like, you note issues. But apart from issue, other ones are silent. You don't just cite issue and then decide to say principle, rule, application, conclusion. Are you solving maths? Someone has passed a property that doesn't belong to him, and you are now meant to, you know, it's a problem question, and it has come to you and meant to write on it. You have framed the issue, whether or not he has the right to pass the title in the first place. And you can't remember any sections of higher purchase act or sections of higher sale of goods that cover these things. What are you going to do? You can simply say, based on the principles of labor that quote non-habits, a man cannot give what he doesn't have. In other words, this is a common law principle that applies here to say that Mr. Okeke has no right to pass a title of land that doesn't belong to him to Okonkwo. And in this case, since he has done it, title has not passed. The land, the person in possession of this land is actually not the valid owner, because the land is a defective title. You may not understand if you're in legal method. This is a typical commercial law example I give. So this is actually how it applies, regardless of whichever way it is. I'm just trying to tell you. Of course, rule of natural justice. What am I saying? The lecturer will give you a question whereby somebody was arrested, no right to fair hearing, he was convicted, and they say examine the legal issue. And one of your issue was whether or not Okeke is entitled to right to fair hearing. You begin to marshal out point. You cannot remember section 36 of the Constitution, which has covered the right to fair hearing. What will you do? You see that according to rule of natural justice, which is the legal principle that apply in this case, it says, and I quote, "Odi autarem partem," hear from both sides. And wherever this breach of natural rules of justice is breached, the law will actually take its course against the person that breached such rule. And such may even brings an action of a court of law or a tribunal to nullity. Case here is Gaba against University of Maiduguri, Josiah against the state, Ahmed against the state, so many other more. So these are the ways that applies. That is how you answer problem questions. And on the part 3 video we are going to do, we are going to actually use a critical examples of how this thing applies. So we'll move toward conclusion. Before we go there, I want you to like this video if you have not done so. Then, if you are watching this video as a downloaded thing, because I noticed that people download the video, whenever you download it, I receive a notification. But what happened is that YouTube will over time delete this video if you just download it without a comment, without a like. It will lead to stagnant of this video that will make them to delete it over time. How about billions of videos are uploaded on YouTube daily? So imagine if yours becomes so went to the downside of the YouTube search engine, what it could mean. They will delete it. So if you have downloaded the video, I have no issue with that. Learn, but then comment. Even if you are watching this video as downloaded, at this point there, comment on your data. The comment will enter. Once you make sure that it has entered, you like it and it has entered, off your data continue. And then they ask for much. Jimmy that is doing this, I'm taking my time. Which way do you want to say thank you? Don't come to my DM and start telling me thank you. The thank you all I need is so YouTube to recognize it. I'm happy that you are seeing this and finding value. I think that thank you is enough. So you saying thank you to the YouTube is to help them, so that YouTube will understand that YouTube is like a robot. It doesn't know anything. It's machine. Left for me, I don't care if you say thank you or not, if you comment or like or not. But the principle say that you must engage. Viewers must engage. Please engage. Engage. Now we'll go to the conclusion. The conclusion now is where the whole things get tricky. And pay attention. Conclusion is as important as your introduction, or is as important as your issue. That's why in part 3, I'm going to tell you how to identify issue and then how to make your issue so strong and catchy. So conclusion, sometimes I will expose this secret to you. Come closer. What lecturer read is actually not everything. Many lecturer don't read everything. I have a privilege of seeing how lecturer, in fact, I have marked one. What they do most often is they read the issue. If your issue is strong enough, they jump to your conclusion. If your conclusion is strong enough, they will give you a full mark. But if you get your issue wrong, no matter whatever you are writing in the body, you are wasting your time. If you get your body right, no matter whatever you are writing without making a good conclusion, a good landing, you are wasting your time. Imagine you writing everything, and then they say advise the parties. You then fluctuate to advise the party contrary to the position of law or contrary to whatever you have written in the body. Is it not appropriating and reprobating at the same time? And of course, the law is that. So it will be a rascality and a double jeopardy mistake. Yes, it will be I don't know English to use, but it will be a bad omen for you to actually, make mistake in your conclusion. Conclusion depends. Conclusion you can conclude in different areas depending on how the lecturer asks you question. If the one that ends open-ended, like examine the legal issues, nothing else again, no A, no B, no like if what has been your reply, if Okeke has done this, if Taiwo has done this. In this case, if you are concluding on the point of law, telling the lecturer everything the law says on that matter. But if the lecturer has made it easy by either raising issue on his or her own, or has made everything so simple that you are just answering, you can then advise the parties. Is in conclusion, you do that. You advise the party that based on section 36 sub 12, any crime that is not written down, it cannot be punished. So I advise the prosecution, I advise the attorney general not to go not to institute these actions, because the action will amount to frivolous charges. And of course, the court doesn't entertain frivolous charges, aside in the case of Amechi and INEC. So these are the things you are going to know. And these conclusions is where you are going to get your main point. Is where you are going to get your whole mark. Is where the lecturer will be like, who is this student? The lecturer, there's a way you will conclude that even the lecturer will take the threat of searching for your name. Because in the exam, you don't write your name unless you do in your school. We don't write names in our own script. So the lecturer can check your range number to know who is this kind, who has this wisdom that is smelling, who has this wisdom that is smoking like this. He will know you. And once the lecturer mark you like this, you're already an A class or in his course, you will pass. So make sure you watch my next video on problem question, because that is where we are going to use a practical example to solve this everything, to solve the whole puzzle we have enumerated on the first video and then this second video. So the second video I mentioned is still, I'm going to link it once we are done with this video. And then the only thing I'm going to tell you is that the only way to receive the third video when it comes is for you to subscribe. Not only that, if you have subscribed already, and you don't receive notification, the only way to solve it is to long press that subscribe button. It's going to show you the option of all notification and none and personalize. Put it to all, and by so doing, whenever a video is posted, it will troop as a WhatsApp, just like there's a notification on your phone. You'll be able to watch it. So I will see you in that video. If you want to watch that video I talked about on the first one that lays the ground to this one, click the link above, and also the playlist. It has more video that will be helpful to you. Until I see you there, make sure you like this video. Remember, King's Advocate is always rooting for you.